Hello, my name is Matt Irell, and along with Ashley Kwan, I'm the co-organizer of the Symposium. We want to thank you again for coming. And I have the great honor of introducing our keynote speaker. And I also have the pleasure of inviting you to a reception in the Great Hall downstairs after the talk. Lawrence Lessig described Professor David Nimmer as, quote, perhaps the leading copyright scholar and practitioner in the nation. And truly, any study of copyright law quickly brings the well-guided researcher to Professor Nimmer's work. His work and opinions enjoy an extraordinary authority, which emanates from the extraordinary care and creativity of their author. Professor Nimmer officially launches a short residency at Penn Law with this highly anticipated address, which he has cleverly entitled Copyright and the Fall Line. We're very grateful he's decided to join us today, and I'm very pleased to welcome and to introduce to you Professor David Nimmer. Professor.
Thank you, Matt, for such a lovely introduction. It's my pleasure to be here, and it's been so knowledgeable listening to the panels that have spoken, which unfortunately emphasizes the shame that the organizers made by their huge mistake in their selection of a keynote speaker. I do know something about copyright, and including its mysterious byways that we'll be getting into. But what, unfortunately, I don't know much about, well, let's put it this way. The fall line to me has nothing to do with seasonal apparel. Instead, it invokes a religious category. And so I intend to spend my time focused on what I do know about. My knowledge of haute couture is just about as naked as these individuals. But I do know something about copyright. I know a thing or two about religion as well. And I've decided to invoke three religious antinomies as the focus of my approach to the procedure of amending our copyright statute to include fashion law protection. The first is the dichotomy between mind and spirit. The second, the dichotomy between cosmogony and evolution. And the third, the dichotomy between esoteric and exoteric revelation. With those considerations in mind, let's bravely move forward. Here we have the ID 3PA, the fashion bill. Now, to me, the most important part of it is contained at the outset, that it is amendment to Section 1301 of the Copyright Act. What is Section 1301? Well, the way the Copyright Act is set up, there are various chapters. Chapter 1 has Section 101, 102, 103, etc. So Section 1301 means it comes from Chapter 13. But here you see the Copyright Act when it was enacted. It consisted of only 8 chapters, meaning when you got to Section 805, you fell off the end and there was no more earth. What then is Section 1301 of Chapter 13? Well, that requires us to go on quite a journey. Here's the bill that was enacted by the House of Representatives in 1975 that became our current Act of 1976. If you investigate it, you'll see something interesting. Title II, Protection of Ornamental Designs of Useful Articles. And included in there is the famous Circle D. Now, how many of you have seen a Circle D? I don't see a single individual. It's not surprising because this was eliminated from the bill. The version passed by the Senate did not include Title II, and when it went to the House-Senate conferees, they omitted any such protection. So we have not historically had design protection as part of our copyright statute. Let's focus on what we did have. First of all, going backwards, Title 17 under the 1909 Act. Very interesting what it protected, various physical items. Here's the very first one, books. If we go all the way back to 1790, we see the same phenomenon. In the Act of May 31st, 1790, if you had been a loyal subscriber to the Columbian Sentinel, you would have realized that Congress conferred copyright protection on maps, books, and charts, which is why the American artist Benjamin West, drawing a painting 1 year later, depicted his protagonist as crying when he realized that copyright protection does not extend to fine art. So books indeed do enjoy copyright protection. What are books? Well, as of 1790, also as of 1909, a book means a physical item, something you can heft in your hand. Pieces of paper and cardboard in a bewildering variety of forms, to be sure, but all of them referring to something physical. Now we have a curious dichotomy that came in the 1976 Act. To be sure, only that which is contained in a tangible medium of expression can gain copyright, but no longer was the expression tethered to a physical object. Instead, it had migrated to a conceptual type, because the 1976 Act now protected literary works. And literary works can be embodied in any evanescent form, including in computer RAM. So we saw that progression. And the same phenomenon, I'll try to sketch it briefly, applies to the realm of movies. Movies can be embodied in old-fashioned forms such as 70mm prints and videotapes, but also in those newfangled computer forms. And so the current conceptual title is audiovisual works, which stands in contrast to the old definition. I mean, take a look at that. Photograph is something that's familiar to us. Photoplay is a term that as of 2012 is barely comprehensible, photoplay. Well, photoplay is simply a photograph multiplied times many times, which gives the appearance of motion when it sits in its can of celluloid. So that's the progression here. And just to give you one more example, works of art. Physical works of art can also assume any one of a number of instantiations, but in addition to that, they could be embodied in that evanescent form through computerization. And so the current conceptual term that our Act gives us is pictorial works, and that stands in contrast to the 1909 Act definition, works of art. As you see, works of art, models, and designs. A design is a physical form that is rather preliminary. A model is a physical form that is intermediate. And a work of art is the final chef-d'oeuvre, the capolavoro, the thing that is produced. So as we see this typology, we see books representing physical items, which were protected under the 1909 Act, and the more conceptual items of literary works protected under 1976 Act, and thus under the other types of copyrightable works as well. So that's our first dichotomy, but life is very messy, and the Copyright Act has been amended numerous times. In the Visual Artists' Rights Act of 1990, VERA, it was explicitly tethered, very specifically, to specific works, such as the outdoor sculpture that was in Indianapolis and the indoor sculpture that was one of a kind, thank God, in the lobby of the Helmsley building in Brooklyn. It's not accidental that these works are protected under VERA. VERA has a completely different focus than the rest of the 1976 Act. It invokes such terms as prejudice to the honor of the artist and focuses on works of recognized stature, distinctions that enjoy no pedigree in any other part of copyright law. And it is explicitly limited to the physical, indeed to the one physical item, whereas all 7 million copies of Portnoy's complaint could be protected. Here under VERA, it's only the single copy, the original, representing the artist's hand that gains protection, or possibly a limited edition of up to 200 copies. So the sensibility of VERA, added in 1990, emphatically belongs to that of the 1909 Act, notwithstanding its codification into the 1976 Act. Well, here's the more complete current version of the 1976 Act with all those extra chapters, the ones that have been added in, including Chapter 13, that is the locus for the ID 3PA. So to understand where we are heading, we need to understand where we have been. And so we'll start with the first admixture, the Semiconductor Chip Protection Act of 1984. It added 14 sections to the Copyright Act. Now, the beauty of the original act, those first 8 chapters that I showed you, is that they were all built on the common law. They were evolutionary. And so, for instance, we had a fair use doctrine that included 4 factors, codified as Section 107, but Congress was very explicit. Those 4 factors are merely culled from prior law, and courts should continue in the same vein. As for substantial similarity, Congress did not even bother to try to codify it, just told the courts, continue in your old vein. There were, to be sure, some technological additions to the 1976 Act, a long provision, the longest one by far, about cable television. But by and large, the 1976 Act was an evolutionary product. By contrast, springing full-blown from the brow of Zeus are these 14 sections of the Semiconductor Chip Act, with an entirely different set of everything. Congress was convinced that we're on the verge of a new era, and in order to keep up to date, we need to add legal protection for semiconductor chips, the famous Circle M. Now, how many of you have seen a Circle M? Good, there's one. You and I are the only ones. I guess you, like me, have pried open your computer and looked inside. And there are those chips inside, and there's a Circle M on them, because this is... say it again, Gideon? Okay, so this enactment has an entirely different term of protection, an entirely different standard for infringement, entirely different registration procedures, entirely different everything. It is an adjunct added on to Title 17, but it is not part of traditional copyright protection. It's drawn from a different universe than the rest of copyright law, meaning that we have now entered a multiverse. Now, what was the reason that Congress needed to do this? Well, going back over a century at that time, there had been trademark protection, which had been very successful in an international treaty. Almost the whole world had joined it. There had been copyright protection, almost 100 years old, also at this time, also joined by the great majority of countries in the world. And so Washington propounded its own eponymous treaty to gain protection for maskworks. Now, how successful has that treaty been in the interim? Well, I have the list of all the countries that have acceded to the treaty. The first accession was Bosnia and Herzegovina. The second was Egypt. And the third and last was, wait for it, St. Lucia. Not exactly the powerhouse of chip manufacturing throughout the world that you might expect. And so the treaty has not even come into effect, as not even the United States will join it, let alone Japan. How many cases have arisen under Chapter 9? Well, there have been a number of them. That's all. That's the number. There have been 3. And those 3 cases are actually won. So in the almost 30 years that we've had this Chapter 9 added to the Copyright Act, it has produced a grand total of 1 reported decision. This is the beginning of what I call the fall line, the line of falling down from the pristine simplicity that we used to have in copyright law. Falling, yes, I'm falling. Sorry, just had to add that. Okay, now next thing we go to is Chapter 10. Chapter 10 was added as part of the Audio Home Recording Act of 1990. 10 sections added to the Copyright Act. Now this time I can even say with more fairness that they emerged full-blown from the brow of Zeus, because this was actually negotiated in Greece by all the interested parties who got together in 1989 and then brought their handiwork back to the United States. Congress made a prediction. Congress absolutely knew with no doubt whatsoever that every man, woman, and child in the United States would soon be outfitted with his or her own digital audio tape drive. You were going to have one in your office, one in your home, one in your car, one on your boat. Everyone was going to have a DAT player. And so it was necessary to add 10 sections to the Copyright Act to minutely regulate this impending revolution. Not only that, but 14 pages of technical minutia of an engineering variety went into the serial copy management system that Congress also added as part of our laws. Now, there were certain exceptions to this law. One of them dealt with professional recording equipment because we didn't want to interfere with them. And another one dealt with something that obviously had to be excluded as of the time in 1990, namely, I mean, who other than the most ridiculously geeky propeller head would do something like listening to music through a computer? So that was accepted as well, because Congress did not have on its mind MP3s, Napster, and the world of 2012. So that was our second example of something that was added on to the Copyright Act. because of the burning need of a prediction that was right around the horizon. And how many lawsuits have been brought based on this law? Well, a number of them. This time the number is 2. But actually the real number is 1 because they're one and the same case again. So the first legislation produced 1 case, the second legislation produced 1 case. Okay, that brings us to the third example, Chapter 11. Now, Chapter 11 is entirely different from anything else you will ever see. It protects jazz improvisations and live recitals. Amazing. I could not believe it when I read the legislative history for this act, because there's a rule in Congress that every bill has to specify its constitutional foundation. After all, the federal government is one of delegated powers, and Congress can only enact legislation if it has rooting in the Constitution. And so it only makes sense to list the constitutional foundation. When I went through the report for the Year-Round Agreements Act, I missed it, so I went through it again. And I missed it again, so I went through it a third time. And I found that it wasn't there. They simply did not follow the rule to list the constitutional foundation. Why? It's not hard to know. Because the law was doing such bizarre and unanticipated things. The first one, the easy one, was that it was resurrecting works out of the public domain. The Constitution says you may grant works for limited times. This took those limited times and added more times onto it, which is why a panel of the 10th Circuit found it to be unconstitutional, although another panel of the 10th Circuit ruled to the contrary. And the case went to the Supreme Court recently, and it's constitutionally was upheld. As I said, this is the easy case, although 2 justices continued to believe that the constitutional foundation was deficient in that regard. But let's talk about the tough part of the law, and that is its protection, its limitation to writings. Now, writings is a fluid term, I understand. It does not refer simply to someone who puts pen to paper or composes on a keyboard. It can extend to artworks and films, as we've seen, sculptures, possibly even the stencils on semiconductor chips that are called mask works. All of those I get. What I don't get is the definition that calls this live recital at Carnegie Hall a writing. Non so più cosa son, cosa faccio, or ti fa corazon, or ti ghiaccio, ogni tono cangiar di colore, ogni tono mi fa palpitare. Also written in 1791, and probably also complaining about her chills because she also realized that copyright protection did not extend to music. But in any event, this is music by Mozart and lyrics by Da Ponte, not subject to copyright protection. It's a live performance in Carnegie Hall. In what sense is that a writing? In no sense whatsoever, which is why its constitutional foundation is extremely suspect. Now, I have actually prepared a movie which I will premiere right now, and I'll just give you the title of the movie. It's never before been seen. The title is On the Constitutional Underpinnings of the Uruguay Rounds Agreements Act in the Minds of the Democrats and Republicans of the House and Representatives and Senate in Congress assembled.
We the people, in order to form a more perfect union.
Academy Award winning, maybe not, but it's my view. It was done, as I say, completely underhanded, without any acknowledgement that there's a problem here, by simply sweeping it under the table and saying, if we don't talk about it, if we don't follow our own rules, maybe no one will realize. Well, that brings us to Chapter 12. The Digital Millennium Copyright Act added these 5 provisions to our laws. Now, I've already talked about the Circle D and the Circle M. The Circle C has been part of copyright law since the beginning, but it never had the force of, let's say, severe criminal sanctions for for the elimination of a Circle C, and many other features that were added by Section 1202. So, what I want to say about the DMCA is the following. A group of professors got together and testified to Congress and called this an unprecedented departure into the zone of what might be called para-copyright, an uncharted new domain of legislative provisions designed to strengthen copyright protection. Now, unfortunately, they didn't hear the lecture thus far, because it's been a straight run from the Circle D to the Circle M to the Circle C, and you add on Audio Home Recording Act, and I call this an only too precedented departure, because all those ingredients were there before. They simply were capitalized by Congress to make the DMCA. Now, nonetheless, the substance of the DMCA was condemned by those same opponents as being drawn, well, let's say, from the fires of hell. I fell into a burning ring of fire. And I have to admit, it has brought copyright law to some extremely bizarre locations. I myself defended Skylink, a manufacturer of a universal garage door remote opener. And I found myself in Chicago defending my client for an alleged violation of copyright law, of the Digital Millennium Copyright Act, because there's software in Plaintiff Chamberlain's garage door opener. And I told Judge Pallmeyer at the time that it's astonishing that, according to the plaintiff's theory in this case, anyone would be liable for violating the Digital Millennium Copyright Act if they found themselves coming home in a rainstorm in Chicago with their own garage door jammed shut, and they sent their teenage boy to jimmy the lock and open up the garage door to their own house. To my shock, the plaintiff's lawyer conceded, well, technically that would be a violation of our rights under the DMCA, but we wouldn't sue for it. Well, the Federal Circuit rebuffed that plaintiff's claim, the Sixth Circuit rebuffed a parallel claim, but copyright law has gone into very bizarre domains because of the addition of this provision. And that finally brings us, at long last, to Chapter 13, and I want to spend more time on Chapter 13 than on any of its predecessors, the protection of original designs. Now, this was added as part of the Vessel Hull Protection Act. It was passed in 1998. A whole 32 sections were added to the copyright law. Why? In order to make the world safe for good vessels. Now, what are good vessels? Well, back in 1989, the Supreme Court had said that state laws prohibiting plug molding are unconstitutional. So I now have to explain what plug molding is, otherwise known as hull splashing. I'll give you a very technical explanation. You take a boat, you put it in silly putty. You take the boat out, and then you pour fiberglass in the silly putty. That is hull splashing. You make a boat in the same shape as a prior boat. So that had been illegal from time immemorial under state law. But as of 1989, the Supreme Court struck down those laws, saying that they're unconstitutional. And so Congress came to the rescue and gave us federal law prohibiting hull splashing. So let's see what they said. It's a problem for consumers as well as manufacturers. Consumers who purchase copied boats are defrauded in the sense that they are not benefiting from the many attributes of hull design other than shape that are structurally relevant, including those related to quality and safety. Quality and safety. Now, I've essentially put the entire basis for the legislation here. There's a little more, but this is pretty much it. This is what Congress said as its reason for passing 32 sections into the Copyright Act. Quality and safety. If the concern is quality and safety, then it seems to me that Congress should have passed a law about quality in boat design and safety in boat design. What effect does it have if you're copying somebody else's design? Indeed, it seems to me I'd rather go on a hull splash design, because at least the first manufacturer determined that it's safe, rather than something that has no seaworthiness whatsoever. So I can't see the nexus between quality and safety and the hull splashing concern. It is also highly unlikely that consumers know that a boat has been copied from an existing design. Okay, so it's quality and safety, and also they're defrauded because they don't know that this design has been copied. And now that also strikes me as extremely inaccurate. A millionaire goes into a shop and says, oh, I love that yacht, she's yar, I want that. He's been defrauded. Why? He's been defrauded because he doesn't know that Acme Boat Manufacturing actually copied that design from Zenith Boat Manufacturing. That's not fraud. The millionaire likes the design. He gets the design he wants, and I don't see the problem. Last problem, most importantly, for the purpose of promoting intellectual property rights, if manufacturers are not permitted to recoup at least some of their research and development costs, they may no longer invest in new innovative boat designs that boaters eagerly await. Okay, so now there's the empirical claim that since 1989, boat designers have been losing gobs of money because of their lack of legal protection. Great. All that's necessary is to put into the congressional record the financials of those boat manufacturers to show that they've been losing money for 9 years. Was any such evidence submitted? No, none whatsoever. So it was a very strange enactment to say that people would no longer invest without any empirical support. But things got even stranger the next year. So there we have, once again, the Vessel Hull Protection Act, a non-evolutionary product, 32 sections added to the Copyright Act because of a perceived need. And how many cases have been brought under that? Well, once again, a grand total of 1. Now, I switched to a different legal commentary to go to my next theme, commenting on Citizens United versus FEC. Professor Colbert says it has not led to billionaires covertly buying elections. There's been nothing covert about it. And I want you to keep that in mind as I go to the next segment. My article in 2004 about copyright legislation analyzes the Vessel Hull Protection Act in some detail. And in order to do so, it looks at the enactment the following year, the Satellite Home Viewer Improvement Act of 1999. So we have to look at the 1998 32 sections that were added in conjunction with what happened to them the following year. Let's look at that Satellite Home Improvement Viewer Act. There are those, as I mentioned before, some technological sections to the Copyright Act. They have to do with ephemeral recordings, satellite broadcasting, cable compulsory licenses. They're so long that they're replete with various grammatical errors. So here's an example of one. This grammatical error that this new law, the Satellite Home and Viewer Act, had to correct. Okay, there's the second one. And here's a third example in the law. And there were others as well. These were called the technical amendments of the Satellite Home Viewer Improvement Act. Now, at the same time as it made those grammatical changes, the feature called technical amendments of the Satellite Home Viewer Improvement Act also reached out to a portion of the act that was not involved with satellites, that was not at all technological, and it made a change to it that was not at all technical. It was as substantive as you could want. Before this language was inserted, the definition of work for hire meant that when Bruce Springsteen went into the recording studio, he owned the recording. After this was added in, it meant that when Bruce Springsteen went into the recording studio and came out, Polygram Records owned the copyright. So it's as non-technical as you can imagine, and it also has nothing to do with the subject matter of satellite home. People have called this a midnight amendment, but that's very unfair. It was actually introduced much later in the early hours of the morning, meaning that no one in Congress had the opportunity to know what it was when it was voted on. It was inserted entirely by stealth. And it caused such an outcry of criticism that Congress had to get together and repeal it. It took a year to put together the legislation that successfully repealed the law. So this is the worst example of stealth legislation, of legislation putting something into the Copyright Act without admitting what you're doing. We've already seen some examples. This is a worse example. But it's not the only example, and we'll see another one that's most relevant to our theme. It concerns Chapter 13, the subject matter into which the fashion bill is designed to fit. That section was passed on an interim basis. It was designed to only last for 2 years, and after 2 years, it would sunset. And because there was so much opposition to this hull-splashing bill, it was necessary to put this sunset in order to garner congressional support. The 2 years was combined with a study that was to be undertaken by the Copyright Office and the Patent Office, and after 2 years, they were to report their results. And then Congress could go back to its experiment to see if it liked it or not. I don't usually agree with the aperçu of Strom Thurmond, but in this case, I think he's exactly right. But even with that, there was still significant objection to the bill, including by someone, a future Attorney General. The bill did pass. And now we get to the kicker. I told you about the first stealth amendment by the Satellite Home Viewer Improvement Act. There was another stealth amendment. Namely, without any commentary or explanation whatsoever, it unceremoniously removed the sunset. meaning that the law that was added for 700 days now lasts for 7,000 days for 70,000 days. Indeed, this will still be the law in the year 2100, the Vessel Hull Protection Act. Now, unfortunately, because we didn't have recording artists going to Washington to complain about the stealth edition, we did not see a ground cry of public criticism, and so Congress was not forced to recant. Congress really should have eliminated its elimination and once again made the Vessel Hull Act experimental, and it should have sunsetted as of 2000, but it still lasts today. So that's the worst example, as I say, of stealth amendments. I added my own commentary. It is impossible to believe that this latter course resulted from any deep study of the practical results of the experimental regime, particularly inasmuch as not a single reported decision transported during that interval. But then, as I realized what had happened, I realized it was more insidious than that. Going back to the very inception of the edition of Chapter 13, something very strange was going on. Look at the chapter. The chapter heading of the Vessel Hull Protection Act. Is it called Vessel Hull? No, it's called Protection of Original Designs. Time after time, the bill goes on to say designs are protected. Does it remind you of anything? 1975 and Title II that was never enacted. The beginning of the legislation says that there will be protection for an original design of a useful article, which makes the article attractive. And it's only when you go much further down into the meat of the precise definitional terms that you find out that a useful article is limited to a vessel, hull, or deck. And so it occurred to me that it would be trivially easy for another stealth amendment to come about and simply eliminate that provision, and then we would be left with the status quo as of 1975, namely Title II would have been belatedly enacted, and we'd have design protection throughout the United States. Well, that's why I say that Chapter 13 was actually conceived in original sin and has been wallowing in sin ever since. As I put it in my article, someone went to the trouble to draft the 32 sections as broadly as possible. One need not be a conspiracy theorist to speculate that the reason behind it might have been to set the stage for yet another stealth amendment to the Copyright Act in the future. So every time Congress passes a law, I hold my breath and I try to determine, has it happened? Has somebody stuck in a midnight amendment or a 2:36 a.m. amendment that eliminates those little words that a useful article means only a vessel, hull, or deck? Well, I'm extremely happy as I come here to this forum at Penn Law School that we are discussing out in the open, indeed with a whole huge audience gathered here assembled, H.R. 2511, the ID 3PA. There's nothing stealth about it, and to that extent, I think it's very valuable. I condemn Chapter 13 for the problems that I mentioned, but the sins of the father should not be visited upon the daughter, and it's no reason to oppose the fashion bill that it happens to be slotted into something that itself was suspect. So in looking at these categories, we can discard with that particular one. What about the fact that it does not represent an evolutionary process? It results from a congressional prediction about what is necessary. Now, I was expecting to go after a panel that had a range of opinion, and I guess I did hear a panel that had a range of opinion. The opinion went from, it's a bad idea, to it's an abysmally terrible idea. My own view of the fashion bill is, well, I'll reserve my view. I'll just say that the experience of Chapters 9, 10, 11, and 12, and 13 of the Copyright Act should lead us to conclude that we should only augment copyright protection once again if the proponents of the bill can come forward with a very compelling case, something that seems much stronger than the bases on which the previous congressional opinions and predictions were based. So, taking a look at these three categories, I would oppose any amendment that had all three of these problems, but okay, let me look at the third one, and that is, what sensibility does it evince? Is it focused on bodily works like the 1909 Act or conceptual works like the 1976 Act? Here we get into some of the meat of the matter, and we see that protection arises, or infringement arises, when there is a design that is likely to be mistaken for the protected design. That means if there's a Christian Dior garment and someone makes a knockoff Christian Dior, if it's likely to be mistaken, and only if it's likely to be mistaken, will there be infringement. This is a sensibility that is extremely redolent of Vera's focus on what is prejudicial to the honor of the artist and focuses on works of recognized stature. Here's another particular. The protection is limited to a unique distinguishable variation. That's a far cry from what Feist said, that there's copyright in any variation, no matter how humble it might be, as long as it's not absolutely trivial. And so that focus on uniqueness, once again, brings me to the fact that just like unique artworks have been protected under VERA, unique designs are now to be protected under the new fashion bill. And so the sensibility of this bill, once again, to me, is redolent of the turn of the last century rather than our governing law. So as I conclude over the course of the next 5 hours as I go through every other provision of the bill, I ask you to consider whether this legislation is designed to bring us to a state that we can all agree will be one of, shall we say, messianic purity. It doesn't have the problem of stealth. It has those other two problems. That's it. Questions? Hi there. Yeah, you. You were heckling me. You were heckling me before. Okay, now I'm going to recognize you. Yeah, well, look, well, don't ask me, yeah.
It's not so easy in this case, right? I mean, because, look, there should have been something proposing this particular legislation. It's not big industry versus little helpless consumer. It's, the entire fashion industry, and a lot of people seem to think that this is not the best idea of our time. So what happened here? How come?
Hey, you're asking for a realpolitik critique. I'm just an ivory tower, thinker about these issues. So I was expecting to bolster my talk with all sorts of little nuggets of defense of it, but I didn't hear it. So we have to ask Matt and Ashley, where are the defenders? You don't have to answer that. Yeah, go ahead, yeah. My goodness, all these law professors, and I've silenced them through the audacity of the presentation.
Well, I'll bite.
Good,
So,
thank you. Thank you, Chris.
the way you present this suggests that your belief is the only way we should be adding provisions is through an evolutionary process, presumably developed by courts as antecedents.
I think that the best way, now I would fully countenance the possibility of alternative vehicles. I simply think we have to be very cautious in light of the track record. So I would apply not a preponderance standard to say, oh, it seems like it's 51% a good idea. I'd say we need to have a clear and convincing standard. If we see a crying need in society and it seems like this will really redress it, then I'd say come up with a non-evolutionary approach.
Can you think of something that might plausibly meet that standard?
You know, I look retrospectively at the Copyright Act and I see all these amendments, and I see failure after failure, except the DMCA has not been a failure in certain regards. The DMCA was certainly attacked viciously, including by those 63 professors whom I quoted. But one of the detractors was Jamie Boyle, a professor at Duke. And interestingly enough, he came to UCLA and delivered the Melville B. Nimmer Memorial Lecture last year, and he repented somewhat. He said, you know what, I said the DMCA was unremittingly terrible. I was wrong, it wasn't so terrible. SOPA is that terrible, he continued. But the DMCA was not so terrible. So the DMCA had a new focus, and the the desire was to unleash the creative potential of Hollywood and record companies and books onto the internet, and to have people feel secure releasing their works. Now, DVDs were released. Probably DVDs would not have been released absent the content control system, the CCS, and the protection for that content control system by Section 1201. So in that sense, the DMCA was a success. Now, people perverted it, and they started suing printer toner cartridge manufacturers and universal garage door opener manufacturers. But in some sense, the DMCA has been a success. So I guess I would say the DMCA was based on a prediction, came out of a diplomatic conference in Geneva in 1996, reached fruition in US law in 1998. Okay, and that was an example of something that was not one-sided. There was a compromise. There was, on the one hand, there was Section 1201. On the other hand, there was Section 512. And so maybe that would be the example that I'd give you. Okay, good. A microphone up here? I finally let you draw your breath.
So I found very compelling the distinction between the 1909 style approach to copyright law and the 1976 Act kind of approach to copyright law. And at the end, I was really blown away by the forms of evidence you gave. However, the standard of substantially identical that's given in the proposed legislation is one that's attracted attention already in the panels. And I just wanted to read it out and propose to you that this is actually, because I'm more of a trademark person, I'd say this is trademark law, coming finally to take over copyright law as it deserves to do. So the standard here is...
They will fight you on the beaches.
Yeah, yeah. And here's the language. In the case of a fashion design, the term substantially identical means an article of apparel which is so similar in appearance as to be likely to be mistaken for the protected design. So I guess I just, since you're here, I would love to hear what your view is of that standards, just in general terms, and also respond to the proposition that this is essentially a likelihood of confusion standard brought into copyright law. And even more generally, just comment, we've heard about the substantial similarity standard in copyright law. What's your view of that standard as well?
Oh, wow, that's a small question. Okay, well, yeah, I was trying to make the point that the fashion bill is redolent of trademark protection. I think Vera is as well. When Vera talks about prejudice to the honor, that's certainly not a copyright standard. It's not quite a trademark standard, but the fashion bill goes the full way and has the trademark standard. Congress was very insincere when it added Vera. Moral rights, le droit moral, is a very serious proposition in Europe, and one can infringe the moral right by, let's say, Marcel Duchamp taking Mona Lisa and painting a mustache on it and selling posters. That would infringe the moral right. Vera is totally different. It's limited to those physical objects. So the only way to violate Vera, if we transport the Louvre to a U.S. context, is to actually go to Louvre, go to La Gioconda, and actually draw a mustache right on her, which, given the state of security in most European museums, would not be too difficult. So Vera, Congress deliberately tamped down the protection to be as minimal as possible because it didn't really want to give European-style moral protection. It just wanted to pretend that we were following Article 6 bis of the Berne Convention. So in this case, again, weird things are happening, and I don't know enough to know why. All I can say is that Title 17 is being accreted with all sorts of standards that don't belong in it. They belong in trademark law, possibly trade design patent law, possibly nowhere, possibly misappropriation under the common law. And I guess I don't know why they're put in Title 17. I was hoping to have a better sense after coming to this panel, but they don't fit very well there. I guess they're not terribly welcome there by any of us here today. Now, your comment about the standards of substantial similarity, I think we should, you and I are both going out to dinner. Once we drink a lot, we might be able to solve that. Okay, any last question? Yes, good. Oh, there are two questions, good. Hang on one second.
You heard us batting around the thought that perhaps protection for fashion design should be embodied in kind of a spin-off of a design patent scheme, like in a protection like in Europe, where there's registered, unregistered type designs, and that it's really not appropriate for the Copyright Act. Any thoughts on that? Whether that's a good idea?
I like your boots. Okay, well, as long as we're talking about sui generis protection, let's go back a step. There are many people, many organizations that support the fashion bill as getting the camel's nose under the tent, because they want protection for all sorts of other things. So what's another thing? Databases. Let's say Wall Street, the Dow Jones Industrial Averages as reported by a certain service. So the Europeans have database protection, and we see the following argument. The United States has no database protection. There's a directive in Europe that gives database protection. In order to harmonize our laws and to catch up with Europe, we need to institute database protection as well. And my response to that is, well, let's look at where the most robust providers of databases are. Are they in Europe? No, their industry is entirely anemic. Are they in the United States? Yes. Well, maybe we're ahead of Europe because we don't have legal protection. Adding legal protection is not a good unless it's actually achieving something. In fact, it's a bad. It's a bad thing to have legal protection towards no end whatsoever. So my answer to you in the fashion context is to say, we need to apply the same metric. I don't know the answer. You'll have to tell me, Barbara, since you know so much more about fashion than do I. You'll have to tell me about the comparative robustness of the industry in Europe and how much you attribute to legal protection. As we heard that from Ms. Reardon, the state of the fashion industry is not bad, and in fact in our hometown of Los Angeles, it's rather good. So maybe it would be even better with this legislation, but I'm not convinced that just because it's out there and just because other people do it, that that's a model that we should emulate. Maybe it's a model we should run from. Oh, and last question, we'll give to Matt. No, that's okay. Let's give this man a microphone. He's the organizer. He deserves one.
Professor, so there was a part of your talk that you just touched on, which was that there are numerous chapters that don't really do very much. And implicit in that, and you just made it explicit, is that it's a wrong to clutter the copyright law with things that don't do much. Is there any way that these chapters are in dialogue with each other or build on each other or lay precedents for each other that it may be, it's not exactly clear to me, even though it seems intuitive clear, why it is a bad?
Okay. Okay. The first part of my answer to you will be addressing Professor Balganesh. In terms of fair use, the question was posed to the panel, give an example of fair use in a fashion design? And I will resolve that question as best I can. The answer is there is no such thing as fair use. Fair use is codified in Section 107 of the Copyright Act. The Copyright Act consists of Sections 101 through 805. Then after Section 805 comes a bunch of miscellaneous accretions, I was going to say a more unkind term, and fair use doesn't apply to it. And it's absolutely explicit. Fair use is not a defense to making a mask work. Fair use is not a defense under the Audio Home Recording Act. Fair use is not a defense to making an unauthorized fixation. Fair use is not a defense under the Digital Millennium Copyright Act. Fair use is not a defense under the Vessel Hull Protection Act. And fair use is not a defense under the Fashion Bill. So that's the answer. And I guess, Matt, that in turn sets the framework for my answer to you. I guess there's nothing inherently evil with having many different multiverses within Title 17, but having laws should be there to serve a utilitarian goal. You know, we shouldn't pass legislation unless there's a need for it, because this legislation causes people to file all sorts of lawsuits and get people into trouble, as we've seen under the DMCA. So the bad of it is that we're weighted down with all these laws that are unnecessary, and we should only pass laws that are necessary. And I hope that answers your question. And I guess that about wraps it up.